Welcome to this free immigration help channel. Today is April 25, 2023, and we are getting into the volume 73 of me answering your immigration related questions. As you can see, I have all your comments pulled up over here. Before I begin, as always, I'm going to mention this is not a legal advice. I am not an immigration attorney. All the information that I provide in these videos on this channel are directly from official government sources like USCIS that I have pulled up here, and of course the visa bulletin from the Department of State. So let's start with the very first comment from Beam Koirala, and I'm sorry if I'm mispronouncing the name. Hi, I applied for my wife and my priority date is 16 December 2022. How long I will take to total processing time? My wife in Nepal. Beam, thank you for your question. So whenever it comes to, inviting, petitioning for a spouse, it really depends on whether you are a permanent resident or US citizen. I will show you how to check the processing times with USCIS. I have it open. I'll use the opportunity to show everyone who is watching. So we're going to go to Tools at the very top of the navigation menu, and you can do it yourself. I recommend doing it yourself because I don't know if you are a US citizen or permanent resident. So we're gonna go to Case Status Online, and here of course you can get the updates for your case. If you put the receipt number that you received on your NOR, Notice of Receipt, that you received from USCIS in response to your initial I-130 application, you can put the receipt number in here and it will give you the status. Most of the times it's very generic, but we're gonna go to USCIS processing times right here. We're gonna click on Visit Page, and in the form, obviously we're gonna select I-130, Petition for Alien Relative. The category that you know better, I don't know if you're a US citizen or permanent resident, so I will select US citizen just as an example. And then the field office, again, this is something that you would have to do your research on and find out which service center or field office your application is being processed at. All right, again, you can find that information on the Notice of Receipt that you receive from USCIS. But let's say it's Texas, get processing time, and there you go, sort of a rough estimate, about a year. A rough estimate because you can see it's 80% of cases that take a year, 12 and a half months, meaning that 20% of cases are processed either faster or slower. Keep in mind, once your petition is approved by USCIS, it is transferred to the NVC. Then you have to get documentarily qualified with NVC, which can take anywhere from 3 months to 6 months, depending on how fast you can satisfy all the requirements to become documentarily qualified. But on the plus side for you, you don't have to worry about the visa cap because for spouses, whether permanent resident or US citizen, well, for permanent resident, there is a cap and there is a wait time right now associated. Before it used to be current, the F2A category. But hopefully we will get to where it is current once again. But if you're a US citizen, then you are not dealing with the wait at all, and you don't have to worry about the visa bulletin. So hopefully this was helpful. If you do have any more questions, let me know. If you want more, a little bit better rough estimates, put your category, which category, whether you're a US citizen or a permanent resident, and also, would be helpful to know which service center it's being processed at. All right, let's move on to the next one from Raza Design. My H-1B case is on audit. How much time does it take? Is there any idea about audit? Okay, Raza, so whenever it comes to H-1B audits, right? And it really depends on your involvement, whether you are employer or employee. Because if you are the employer and you are being audited, let's say, for example, based on some complaint from the employee, right? And the employee is in H-1B. Then of course it all depends on you, because it's really up to you how fast you will satisfy the whether it's because Department of Labor can start the audit, H-1B audit on you, USCIS can start the audit on you. And obviously whoever is starting the audit, they will have their own things that they need from you to find out. They will request some kind of documentation, and the faster you can provide that documentation and answer their questions, that's it. The faster the audit is taken care of. Now, of course, this is a little bit different if you are the employee. Now, of course, well, you really can't, you're not really in control, because it is the employer that works with the Department of Labor and USCIS satisfying that audit. Then really it depends on them. But if you are the employer yourself, then you are obviously in control. Just make sure you are prompt with whatever documentation they request, whatever questions they have, and it shouldn't take too long if there are no problems, if there is nothing that is, if everything is good on your end, then you will be able to provide all that information to these, agencies, organizations, and should be taken care of pretty quick. All right, let's move on to the next one from Emily Marshall. Are you able to provide clarity, because in the video you keep referring to the dates for filing chart means that your visa is available. However, my understanding is that this chart indicates you are able to submit your documents to NVC or USCIS for AOS. If that is the chart being used that month, it's the final action date, the chart, that indicates visa availability. Please clarify. And I'm going to read the next comment. The reason why I ask is because in the final action date table state only applicants whose priority date is earlier than the final action date visa can be issued, which means being current on the filing chart and not also on the final action date. You may not get an interview because your visa won't be able to be issued until you're current on the final action date. Note, I know this isn't applicable to immediate relatives. Yes, Emily, so I'm sorry for if I caused some kind of confusion with my answers. The reason why I use, as of right now, the priority dates, the chart B instead of the chart A, is because the chart A, it has not been updated for a very, very long time. We finally have seen some movement, specifically for the F2A, and I believe as of May 2023, we have seen some movement in the F1 as well, only like 15 days, which is really, really nothing. That's why I usually rely on the graph B, because you cannot change the filing date, right? You submit the I-130 petition, you get the receipt from USCIS, that's it. The application is started and it is basically in process. However, whenever it comes to becoming documentarily qualified, which is now we're talking about the final action date, there was instances in some of the cases, in some of the categories, where people were allowed access, the full access to the portal, the NVC, the CAC portal, earlier, way earlier, before their immigrant visa was available. And in some instances, they were waiting closer to the availability of the immigrant visas, and then they were allowing. So if we just go and judge by the final action dates, if we look at just the graph A, it might create a completely different picture. That's why I try to go to all the way back, because you cannot change those dates. And when you look at the graph B, it right there, it tells you whether the person was waiting for 10 years or 15 years or 5 years. And from then, you can already, whether they're documentarily qualified or not documentarily qualified, we can make a little bit better estimates, at least as of right now. Because obviously, you know, if you are way past, right? If you're, let's say, a year over the priority date, right? So let's say, for example, I'm going to pull up the visa bulletin. Let's say we're looking at the priority one, the first preference category on the chart B. It shows January 2017. Let's say if someone is waiting now since January 2016 and they're wondering, now we already know, okay, so they have been waiting the whole year over the date that is shown on the graph B. So we already can kind of estimate that the person most likely should be either documentarily qualified already by now, or the process of becoming documentarily qualified, basically the full access to the NVC portal, should be open for that person literally like anytime around the corner, because they're very, very close to the availability of the immigrant visa. That's really the only reason why. I think hopefully all the dates will kind of normalize and we will have everything updated. We've seen with the issue of the April visa bulletin and May visa bulletin, we have seen some movement. So I think in the next few months we will have everything normalized, and then we will be able to look at the priority dates and then obviously the final action dates, and kind of have a better information, better insight into what's happening. But as of right now, if you just look at the final action dates, it really creates the picture that really nothing is being done, which is really sad, and that's why a lot of people are confused. But I'm very sorry if I created some confusion with this. This is again kind of a temporary technique, if you want to call it that. But yes, you are absolutely correct, 100%. That's how it should be, and hopefully in the next couple of months we will normalize with the dates, and we will be able to just look at the dates. And if you're already documentarily qualified, then you look at the graph A. If you're not documentarily qualified, then you look at the graph B. All right, let's move on to the next one from Lionel Jane Legaspi. Hi, may I ask when your priority date is April 7, 2021? How will I know it in bulletin? I don't know how to do it. Lionel, thank you for your question. So it depends on which category you're in. So you need to determine which category. So if you look at the visa bulletin, it explains you specifically which category is what. So the first priority, first preference category is unmarried sons and daughters of US citizens over 21 years old. I don't know why they didn't put it here over 21, but it is for over 21. The second priority goes specifically for the permanent residents who are petitioning for their spouses and children who are in F2A category, children being unmarried and under 21. And then F2B category is unmarried sons and daughters, 21 years of age or older of permanent residents. Third priority category is married sons and daughters of US citizens, and the fourth priority is brothers and sisters of US citizens. So whoever you're petitioning for, you will be in a certain category. There are of course some immediate relatives, I say in quotes because that's how USCIS and Department of State, Department of Homeland Security defines them, right? In those instances, they're not applicable to, the visa bulletin is not applicable for those situations at all, because there is no cap. There is no visa cap for those immediate relative categories. Like, for example, a US citizen inviting their spouse, or US citizen petitioning for their child that is unmarried under 21. That's considered immediate relatives. Or for example, US citizen petitioning for parents. Again, immediate relatives. The whole visa bulletin is not applicable. We don't even need to look at that. But again, like I was explaining in the previous comment to Emily, if you are, if you know your priority date, you're looking, and you are not documentarily qualified yet, you're looking at the graph B. If you are already documentarily qualified, technically you should be looking at the graph A, but because it hasn't been updated for a while now, it's a little bit easier to make the estimates from the graph B. So hopefully I was able to explain that, Lionel. If you have any questions, just let me know the category and chargeability. I did not mention in my response the chargeability. Basically, there is 4 countries that have their own separate chargeability area: China, India, Mexico, Philippines. Everybody else is in all chargeability. So if your beneficiary is from one of these countries, then you're looking at these dates. If not, then you're looking at the all chargeability right here, depending on which family preference category. All right, let's move on to the next one from Autumn. Thank you so much for answering my question. Of course, Autumn, you're very welcome. I will come back soon to testify of my interview email from the NVC in Jesus' mighty name. Amen. Autumn, thank you very much for your kind comment. That means a lot. I do enjoy getting your questions, but when you follow up, I enjoy that as well. Because it tells me that, my answers, they're not just, random. And again, I'm not an immigration attorney. I'm not, I did study for this, and I did work in this industry for a long time. But still, this is not a service. I don't make any money from this. I don't make any, I'm not trying to sell you anything. So that's how I want to keep it. So that's my blessing right there, you know, a response like this. All right, let's move on to the next one from SLP. If I am filing out this application for a P2 visa, do I still have to put NA or none on all other classification supplements that don't apply to P? Okay, SLP, excellent question. Thank you for asking. Because I-129 is probably one of the only applications that you're submitting where you can completely leave those blank and not worry about going through the whole thing. And SLP, you brought up a good point. I'm gonna mention it since we're discussing this. If you are filling out a paper application, all right? First of all, if it's available online, I recommend submitting it online because you don't have to do it in online application. You do it only in the paper application. But the general rule of thumb, the requirement from USCIS, I think they even mention it somewhere. I think they mention it in some of the instructions for some of the applications, is that don't leave any blank field, all right? Let's say you don't have a middle name and there is a middle name field. Don't leave it blank. Put N/A for not applicable. Don't put none for the middle name just in case somebody confuses and thinks that, because, you know, we are immigrants, all right? Our names are different. So for someone to look at the none in the middle name, it might seem like, well, that's a middle name, none. You know, Jason None Statham or whatever, something like that. So for middle name, put not applicable. But let's say there's a field for Social Security and you don't have Social Security, put none. Don't leave blank fields. I cannot tell you 100% why they have that requirement, but I can tell you 100% that I have seen hundreds of applications come back, and even on this channel, people were like, hey, my application came back, they said fill out those empty fields. They will send it back. They're not gonna deny it, but they will send it back to you and say, hey, don't leave any blank fields. It's not a huge deal, all right? Really, you're just getting your application back as it is. You're doing the corrections and then you're sending it back to them and then they accept it. So it's not a huge deal. It's not the end of the world. The problem is that you're just wasting time, you know, because you mail the application, they review the application, they go through it, and then they send it back, and so far, so forth. So SLP bringing up an important point. However, the I-129, because the nature of I-129 is such a diverse nature, right? It's a huge application, and there are a whole bunch of these supplements for all of these different visa categories. That is one of the only applications where you don't need to worry about those. If that whole supplement is not applicable to you, just leave it blank and send them the blank page. I know it sounds ridiculous. It's a paperwork, it's a bureaucracy, but that's what they want. Make sure to send the whole application, every single page of the application. In the most recent edition, it is very, very important to do that. And for all of those supplements, you can leave them, you know, not even address them, not even look into them, because they're not applicable to you. You don't have to go through all of them and fill out all of them with none and not applicable. SLP, I'm very sorry I'm taking forever with my answer on your, but it's a very important point, and it might help someone. So it's really good that you brought this up. Let's move on to the next one from Greep Vlogger. Greep, by the way, thank you for another question. I appreciate it. We submit our case I-130 13 December 2022. And on 23rd January, USCIS started reviewing my I-130. I'm spouse of a US citizen. Sir, you answered me in the previous video and asked me that if I get the welcome letter already. I didn't get welcome letter still. It's showing that 23 January, we actively reviewing your case. All right, Greep. So while I have the processing times, because I know now that your application is still with USCIS, and I know when it was filed, it was when it was received. I don't know which service center it went to. Do I? No, I don't, but that's fine. So we got I-130. We know that it's a US citizen that is petitioning for you. Texas Service Center is about a year, and not a year and a half, but 12 and a half months, all right? The year, let's just say a year. So if you have submitted your case 13 December 2022, and so January So January 2023 is your priority date. All right, January 2023 is when USCIS have accepted your application. So if it is processing in Texas Service Center, you know that by January 2024, your case hopefully should be reviewed. Now again, depending on which service center it was sent to, let's say for example California, I think it is actually longer in California, it's 15 months, so a little bit extra in California. But you're looking at about a year of processing with USCIS. Once it is approved at USCIS, your case will be transferred to the NVC. When it is transferred to the NVC, pretty quickly in your case, you will receive that welcome letter. And I say in your case because you are an immediate relative of US citizen, so there is no visa cap that you have to be dealing with. This whole visa bulletin for you, you don't even need to worry about it because you are in a category that there is no limitation on availability of the visa. So yeah, that's really it. I can, only thing that I can wish you is patience. And I know it's might not be the best or most pleasant thing to do, wait. But most of the times, unfortunately, whenever it comes to these petitions, these applications with, immigration especially, it's a wait game a lot of times. But you're staying on top, you're finding out information, you're being aware. That's really the best that we can do, just on our end, being in control of the situation and making sure that your case is within the normal processing times. And if it's not, then of course you take action. But as of right now, everything seems to be going fine. So just patience, my friend. All right, let's move on to the next one from Mubashar Hassan. Question, volume 28. Before the expire admitted stamp must going out the country and come back like in out, is it necessary? Mubashar, I don't think I understand your question very well, but you commented on the form I-551. And that is an immigrant visa / a temporary permanent resident card when you enter the United States. So I'm not sure exactly what you meant by the question, but it is necessary to enter the United States of America with I-551 for it to convert from the immigrant visa to a temporary permanent resident card. All right. If that's what you were asking, hopefully this was helpful. If not, please let me know a little bit. Maybe rephrase the question, and I will be happy to address it in the next volume. All right, let's move on to the next one, to Levi Pulido. Thank you. You're very welcome, Levi. Moving further, we got another question from Kills J Tech. Kills J, thank you for another question. Your comment, appreciate it. Hi, sir. I have two options, sir. All right, let's take a look. Is it safe or effective that I send my follow-up on public inquiry every week or once a month? No. I think the only reason that they accept is medical condition of petitioner or age out of your children. If you request on expedite, correct. My question is, do you have other reason that acceptable for expedited except the two that I mentioned above, sir? Anyway, this informative video was very helpful. Thanks, sir. Killsjay, you're very welcome, and thank you for another question. Actually, it's a really good question. So there is two different actions that you can take with the NVC. If for whatever reason your case is taking too long, or there is some kind of circumstance that that is involved that needs you to take this action, you can submit the public inquiry form. And I have shown how to do that. I actually have this public inquiry form right here pulled up in front of me. This is the official government website. In fact, there is a situation in Sudan, April 23. I have to take a look what's going on there. But this is the official Department of State website. And you are submitting an inquiry directly to the NVC. So they receive your inquiry. And a lot of times, if you see that in the visa bulletin, you already, you have passed, the dates are passed, it's showing that the dates that you should have already your immigrant visa available, or you see that your case should already be documentarily qualified and it's not, so there's a delay, then you can submit that public inquiry form. I would not recommend doing it every week, not at all. You can probably do it like once every other month if you're only getting a generic response, or if you're not getting a response at all and you know for a fact that your case is being delayed. Don't send it every week. That's definitely not a good idea, because it will definitely bother somebody, and you definitely don't want to do that. And the second option that you're also talking about is submitting that expedited request. Now, for expedited request, there are two main criteria that you have to meet. The first one is you have to be documentarily qualified. All right, so you already have to, the final action on your case has to be already taken, already documentarily qualified. And number two is your immigrant visa should already be available, judging by the visa bulletin. If you meet those two requirements, you can submit the expedited request. Now, yes, it is true. When you submit the expedited request, you have to have serious reason as defined by the Department of State, and the same thing for USCIS as well. Like, for example, financial hardship, some kind of medical condition, something. But as I always say in pretty much every video that I make, if you are documentarily qualified, if your visa is already available, judging by the visa bulletin, go ahead and send that expedited request. Regardless, be polite, be professional, but go ahead and submit it. Because if if we look at the core of our situations, right, we're immigrants and we're filing for reunification with the family. It is our family members that we're talking about. So considering how long we have to wait in order for our family members to go and get that immigrant visa to come and be with us and reunify, people wait for years, 5 years, 10 years, 15 years. That is an emergency, all right? If you have been separated from your family for so long, that is an emergency situation. It's natural to be together with the family. And due to the process, due to the way the system is set up, families are, they're living their lives separated because of it. And it is an emergency. So as long as you're documentarily qualified, as long as your visa is already available, that's why I say, don't hold back and submit that expedited request. But for expedited request, yes, you have to be DQ and the visa has to be available. For the public inquiry form, none of this, you don't need to care about any of this, except that your case has to be already approved by USCIS. Because if your case is still with USCIS, then there is no point of submitting the public inquiry to the Department of State. You need to submit your inquiry to the USCIS. All right, Kills J, I hope this answer was helpful. Let's move on to the next one from Sandeep PS. Sir, my husband is US citizen ND GILE, probably misspelled something. My case in October and file my case in October 2022 on 21st October in Texas Service Center. But after that, I did not get any update. When I will expect the update of my case for I-130? Okay, so your husband is US citizen. We know that. Let's take a look at the processing times. So petition I-130, US citizen filing for spouse, and we know it's in Texas. Let's take a look. Texas, I think it was 12.5. So your case was filed on October. Okay, so it's October 22. So roughly we are looking at around October, November 2023. So you're good. Everything is within normal processing time. Just again, patience, as I know that's not the best thing, but when I say patience, and it goes for everyone, if you already don't know, I have a petition myself. And I have to be very, very patient because I have to, me and my brother that I'm petitioning for, there's like a long time. It's so long that I don't even want to remember it. It's really a long time that we have to wait. So when I say patience, please don't misunderstand me like I'm being insensitive and I'm saying, oh, just be patient. But unfortunately, this is the system that we're dealing with, and that's how it is, Sandeep. But everything is good in your case. It's within the normal processing times. Like I said, judging by what we have right now, and again, it's 80% of the cases. So your case might take a little bit longer, and it might take a little bit faster. All right. But as of right now, everything seems to be fine. All right, so from the comments, this is going to be the last one. I actually received 2 of the emails, so I'm going to address them here as well in this video. The first question, and for everyone who's watching, if you can, please stick to the comments because they show up all in one page and with the emails. I actually had a few emails that I discovered way too late because they went to the spam folder. I don't know, for some reason for these emails, they just go to the spam folder and I wasn't able to address them on time. So if you can, please put them in the email. So the very first question we have from Kalika Novoa, and I'm reading the email that I have in front of me here. We filed a I-601A waiver in 3/1/2020, and we filed an amendment to that waiver on 4/4/2023. Okay, so on November 21, 2022, we received a message from USCIS Nebraska Center telling us that our case is in line to be reviewed by an officer, and that the earliest that we can submit questions to them is April 29, 2023. Questions. Do you think that filing additional amendments so recently would delay an answer? No. So if you do have an important update, definitely submit it as soon as possible. And it goes for everyone. If there is any kind of change, let's say, for example, if, obviously here we're talking about the I-130. If someone doesn't know the I-601A waiver, I don't remember the name of it correctly, but it's basically the waiver that waives the unlawful presence in the United States because there is an I-130 petition for that person that is going. So if there are any changes, and it especially happens a lot with I-130 because the wait time is so long, so statuses change. People file as permanent residents. By the time it's processed, they're already U.S. citizens. It's a change. Make sure to provide updates as soon as you experience those changes. Will they delay? In some situations they might, but it is still better. Even with considering the delay, it is still better to keep these organizations up to date on everything that is happening instead of them finding out later and causing problems down the road. All right, question 2. If the reply to the waiver is positive, is the next step an interview at the consulate? And if so, what would be our next task? Okay, so with that question, I'm gonna ask you for a follow-up, and if you can provide it in the comment on any of the videos, it doesn't matter. I would really appreciate it. I might be able to give you a little bit more information. But if your waiver, because your case is still with USCIS, if your waiver is approved, right, then of course USCIS, they move further with that I-130 petition. And if it's positive, obviously the answer on the I-130 would be positive as well. If it is approved, then it is moving further to the NVC, and then the NVC, got the birds going crazy here, with the NVC, when they receive the case and they see that the person is actually in the United States, they send you a letter or an email, letter in the email, saying that, hey, since he's here, since, you don't have to deal with the embassy processing, you will still have to become documentarily qualified and stuff, but it's going to be a little bit of a different process because you're not dealing with the US Embassy. You will be actually dealing with immigration field offices here in the United States of America. All right, and the question number 3, is it advisable to hire an attorney for the final steps in this process? Great question. So whenever it comes to waivers in general, I would recommend having an attorney. It's definitely, it's only helpful to have an attorney if you have a waiver, because a waiver is a little bit of it's a little bit more in depth of the process, if I may say so. So it would definitely be helpful if you find a good attorney. However, if you do get a positive response on the waiver, and if everything is moving along fine, and this waiver is approved, I would say that was the most complicated process right there. And you went through it without an attorney, so the rest, you really don't need an attorney. I would say consider an attorney if you are still experiencing the problems with this waiver. So hopefully my answers were helpful. I'm going to read some of the information is priority dates, 2018, the help that you're giving to so many is beautiful example of selflessness. No need to thank me whatsoever. So I appreciate it. All right, let's move on to the second email that I have is from LMT coach Adele. Hi, Immigration Help. Thank you for amazing information you provide on your channel. I'm a bit pressed for time, but I want to make sure I am taking the right steps here. This is the reason why I am reaching out to you. My husband has a B1, B2 visa from Belize. I am the wife petitioning for him. I already submitted the I-130, but they are asking for the other thing that I mentioned in the comments on the YouTube video. What should I do with this response? My husband is living here in the US with me at the moment, but for some reason it seems that there is some other waiver or something where he can stay here and do the interview here. Yes, I was just talking about that waiver. Please help me with this. Looks like the I-130 is mainly to get the spouse to be here in the US, but in my case he is here on that type of visa. I remember when I filed for my green card, I was already living here and also had a B1, B2 visa. They just needed my I-94 and waiver. I'm not sure if that changed. Okay, and then you put their response from USCIS, and the response says, why we're writing to you on July 6th, blah, 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 you submitted your form I-485. We're writing to inform you that we need more information from you to make a decision on your case. Please read this letter carefully and follow all the instructions. You must provide the following information. You have submitted form I-485, application to register permanent residence, and all pages of the form are not present of the same edition date. We were just talking about it. Let me take a look at something. We're going to go to forms, and I want to actually open up 485 because I'm pretty sure it is not available to file online. So first of all, Adele, this is very important. I don't know where you got your application, but it almost seems like you did not get your application from the official USCIS website. This is the website, the official .gov government website. This is the link that you need. I will see if I can find your comment and post that link in there. I probably won't be able because I do receive so many comments. But you want to make sure that you're using the most recent, and you have the edition date right here. Right now we have 12/23/2022, the form I-485, and we're actually going to open it here, and let's see, yep, edition date 12/23/2022. So that's the one that you want to use for your I-485. Whenever you're sending the application, make sure to send all of the pages, because you see right here it says page 20 of 20. You want to make sure that all of the pages are present in the application and none of the pages are missing. Even if they're not applicable, you still have to include them with the application. So that's number one concern. Let me read the second one. You did not submit a properly completed and signed form I-864 affidavit of support for petitioning sponsor listed on form I-130. Okay. So the affidavit of support is I-864. Now, it seems like you decided to start the process because you have a couple of options, right? With the I-130, you have a couple of options when the beneficiary who you are petitioning for is in the United States of America. You can submit just the I-130 and then wait while it's being processed, while they become documentarily qualified, while they get their whatever, basically all the financials are established, the relationship is established by USCIS and then National Visa Center. And then they give you an option to submit the I-485, basically to register the permanent residence because the person is already here. Or what you can do, and it seems like that's what you did, you can submit everything together, I-130 and I-485 together. In that case, yes, you do have to submit that affidavit of support as well. The petitioner, even if you have a joint sponsor, you still have to submit that affidavit of support. You don't need to worry about the waiver that I was talking about in the previous email and the previous response, because that waiver is specifically when the presence was unlawful, meaning that, and I know it sounds bad, but it's really, and a lot of times it happens. It's really not that terrible. But basically, let's say if your husband stays here on B1, and you filed a petition I-130, and they stayed here, they overstayed their stay, that they could, they could legally be present in the United States based on their duration of stay, based on their entry with the B1, B2 visa, okay? In that case, you do need to file that waiver. But it seems like in your case, you don't need to unless they are here already past that duration of stay. If that's the case, then yes, but it doesn't seem like you need to do that. Okay, so they tell you, submit a completed and signed form I-864. Definitely need to do that. Provide the petitioning sponsor social security number on the form I-864. Provide the calculated household income size on form I-864. Submit a complete copy of the petitioning sponsor's federal income tax, all supporting tax documents, W-2s, 1099s for the most recent tax year. We also need to submit form I-693. Must submit this in a sealed envelope containing the original form I-693 that the civil surgeon signed and the medical exam result. They will not accept photocopies. Yes. So, unfortunately, as of right now, hopefully, there is a talk in the future that this might change, where they don't require a sealed envelope. But as of right now, it is still in place. You have to go to the doctor, the civil surgeon, do the whole medical everything, and then they fill out whatever they need to fill out. They seal the form in the envelope, and you cannot open it. And that envelope you have to send together with I-485 and your I-864, the affidavit of support. The only reason why you're dealing with all of this, so it's like so much stuff right now on you, I know it's overwhelming, but the only reason why you're dealing with this is because you decided to do it all together. It's not bad, because if you do it all right now, it means you don't have to deal with it in the future. You have an option to just submit the form I-130, but, he's here, might as well do it all together. So I know it seems overwhelming, but just take it one step at a time. You already done I-130, now you need to concentrate on I-485. Once you find the correct edition date, all of the pages, fill it out, Once it's done, do the I-864. That one is not that bad at all. And I-864, you don't have to deal with it in paper. When you submit the I-130 just to USCIS, they approve it, case moves to an NVC, then you do it online, right, in the portal, in the NVC portal. That's what it is for. But because you don't have to deal with it, you're dealing with it now. So hopefully, I know my answer is kind of like all over the place, just because it really is a lot of stuff that is involved, but it is not that bad. It's not that bad, and you can definitely figure it out, and one step at a time, you can definitely take care of it, because it only seems scary right now because there's a lot of stuff involved, but it is not that bad. Okay, so let's do some more questions. Why not? Let's move on to the next one from Latifa. I mean, we are already 10 minutes, 12 minutes past that 30. We will make it a longer video today. Whatever, that's fine. If you guys are willing to watch, I'm willing to answer. Actually, you know what? Before I forget, let's put this here, and let's put this here before I forget, because I will forget. All right, next question from Latifa Molik. F2A Documentarily Qualified 2 years and 6 months. Now when start will interview? Answer me. Wow, Latifa, congratulations. So just recently we got the information on April 2023 visa bulletin. So looks like people who have been documentarily qualified in F2A category, they are waiting for 2.5 years. And you were waiting already for 2.5 years, which means that interview literally should be anytime now. If you want, you can submit the public inquiry form with the NVC that I was talking about earlier in the video, just to give it a shot and see what they say. But your immigrant visa should already be available, and literally anywhere around the corner your interview, because that's what we see. All right, let's take care of another one. Elizabeth Jagdane, sorry if I'm mispronouncing the name. Hi sir, I had filed for my married daughter in December 2010 and I got the approval in March 2015. How long will it take, and how long will it take? My daughter is in India. We filed in California. Thank you for your help. So Elizabeth, I'm assuming you are a US citizen filing for your married daughter, so that is category F3, and there is a separate chargeability area for the India. So let's take a look. We got, actually it's the same as all chargeability, so it doesn't matter. So the priority date looks like it's February 2010, and you have filed in December 2010, which looks like you still have about, let's see, February 2010, you filed in December 2010. So you're still looking at about, my math is absolutely horrible, like what, like 8 months before your case is actually ready for, documentary qualification, before it's really close to the availability of the immigrant visa. So I would say give it another year. You can give it another year to see. But another thing to keep in mind is that all of these numbers that we see, they haven't been moving for a very long time. We are now seeing some updates because we had the closures with the pandemic. So hopefully we will see some movement and things will speed up. In the next couple of months, we will find out. But a very rough estimate, you're still looking at, closer to the end of this year at least, to see, what's for the case to move further. Sorry, I wish I could give you a little bit better estimates, but as of right now, it's really hard to tell. All right, let's move on further to Mark Tungol. Mark, thank you for your comment and thank you for being publicly subscribed. Thank you for answering my question, sir. It was for I-130. Thank you, I appreciate it. You're very welcome. Oh, and I forgot actually to put this here. Let's move on to the next one because why not? Probably the last one for today from Trudy Bubs. Hello, sir. I hope this time you see my message. Trudy, I'm very sorry if you already posted a comment and I didn't see it. I get so many comments and it's becoming harder and harder for me to keep up. So if I'm not answering your comment, please post it on more recent video and hopefully I'll get to it. I'm very sorry if I'm taking long to get to your questions. I really apologize. Hello, sir. I hope this is done. I have been sending message from volume 69 and 71, 71. Sorry, Trudy. I'm really sorry about that. However, I have followed your advice and sent a public inquiry and we see a reply by saying they haven't reached my priority date. I don't know if it's an auto reply, probably, or if it's someone actually read my message and reply. Sir, I'm F1 priority date, April 2017, documentarily qualified, June 2021. Sir, is it the case NVC is still working with Bulletin A that show priority date December 2014 and not Bulletin B that show priority date 2017? I'm confused. Please tell my next step. Thank you. Trudy, yes. So when you are documentarily qualified, right, that is the final action. Technically, yes, you're correct. And I don't remember the name of the person I was answering earlier in the video. It is the graph A on the visa bulletin that we should be looking at because it is the final action dates, meaning that these are the cases where the final action was already taken. These are the documentarily qualified cases. However, because it has not been updated for so long, it is really hard to be accurate and judge by the graph A. That's why I work and give the rough estimate using the graph B, because these dates, you can't change them. Priority date is the priority date when you file the case, that's it. With documentarily qualification, again, like I answered earlier, you can have it closer to the availability of the immigrant visa, or they can give you an access early on and you're documentarily qualified and now you're just waiting for that availability of the immigrant visa, already documentarily qualified. But with that being said, because you're already documentarily qualified in June 2021, and because the only most recent update, the only clear update that we have for the category that used to be current, which is F2A, and they're waiting as of right now, being documentarily qualified, waiting for an interview for 2.5 years. From that, we can do some rough estimating still, but much better estimates compared to just looking at, for example, the F1 and looking at the December 2014, because that makes no sense. It doesn't take, it doesn't take 2-3 years normally after you're documentarily qualified to wait for your interview. The only reason why we see these 2.5-year delays is because of the whole situation with the pandemic closure. But The updated information is in F2A, and it is roughly 2.5 years. Again, yes, because of the pandemic closure. And since you're waiting since June 2021, which means in June 2023, it's going to be exactly 2 years. So roughly by the end of 2023, beginning of 2024, that's where you can somewhat safely, somewhat accurately predict that interview that you're waiting for. So very sorry, Trudy, that I'm getting so late to your comment, and for everyone, if I'm getting late to your comment, I apologize. You see, took a 50 minutes to answer the questions, and I still probably didn't get nearly to all of the questions. I hope I figure out the way to speed up this process of answering the questions. Maybe someone will be able to join and help me with answering the questions in the future. We will see. But I promise you, as of right now, I'm doing my best. And if I'm not able to address it on time, just post it again in another video, and I will address it. So thank you everyone for sticking around for so long, such a long video. This is going to be a long volume to watch. Apologies for it being so long. And always appreciate your time, appreciate your questions and comments. God bless everyone, and I'll see you in the next video.